So we're finally getting into the kind of the meat of the hearing for the Supreme Court nominee, Judge Jackson. And what we're starting to see is some questions about judicial philosophy.
What is your judicial philosophy?
So I have a methodology that I use in my cases in order to ensure that I am ruling impartially, and that...
So your judicial philosophy is to rule impartially?
No, my judicial philosophy is to rule impartially and to rule consistent with the limitations on my authority as a judge. And so my methodology actually helps me to do that in every case.
So you wouldn't say that you're an activist judge?
I would not say that.
An interesting move, because she's been endorsed by all the far left groups. But when she's asked questions about judicial philosophy, she's not giving the typical left-wing responses. It's kind of leaving it very vague.
It's required to be impartial. But the judicial philosophy is, what is the basis upon which you arrive at a decision? That's what judicial philosophy means. For Justice Breyer, for instance, he believed and wrote a book about it called A Living Constitution, that the Constitution is basically a living document. It changes with the times. Famously, Justice Scalia, in a dialogue that they had, took the opposite view. He was a constructionist, what we call today a constitutionalist. He believed that you interpret the Constitution based on the words of the Constitution.
I don't know how long she'll be able to dance around that by using this methodology, which is obviously the term they came up with.
Impartiality.
And impartiality, because that is just assumed. I mean, you're not qualified to be a local judge if you're not going to be impartial.
Would you like to comment at the outset of those who are looking for a label, what your position is on judicial philosophy?
Over the course of my almost decade on the bench, I have developed a methodology that I use in order to ensure that I am ruling impartially and that I am adhering to the limits on my judicial authority. I am acutely aware that as a judge in our system, I have limited power, and I am trying in every case to stay in my lane.
Methodology
Right.
versus judicial philosophy. And again, to me, that just, when I'm reading through it, it just sounds a lot more like a trial court judge going through the motions.
She served 8 years as a
going
trial
through
court judge.
like all the stuff you got to go through to be right, like your speedy trial, like you talked about, and these kind of things. But that is very different when you get to these more esoteric level decisions at the Supreme Court level on fundamental rights, like she was asked about, and what's there in the Constitution and what you read into the Constitution and what is it this living document where you can make up rights as you go.
Could you tell me how you might go about deciding what a fundamental right is under the Constitution?
Well, Senator, I don't know that I can tell you that in the abstract in the sort of way that you may have posed the question. There is precedent in the Supreme Court related to various rights that the court has recognized as fundamental. The court has some precedents about the standards for determining whether or not something is fundamental. The court has said that the 14th Amendment substantive due process clause does support some fundamental rights, but only things that are implicit in the ordered concept of liberty or deeply rooted in the history and traditions of this country. They're the kinds of rights that relate to personal individual autonomy, and they've recognized a few things in that category, and that's the tradition of the court for determining whether something is fundamental in that way.
There's not a lot yet to take away from what she's saying. It's again, they're trying to nail down the basics. Like, what do you see as a fundamental right? And it wasn't clear.
Which should have been the answer to that been freedom of speech, free exercise of religion, freedom of the press, freedom of association, the fundamental rights as outlined in the United States Constitution.
If that was asked of Brett Kavanaugh, Gorsuch, or Amy Barrett, they would have mocked them, said that wasn't, they would have hammered them back down
So that
and
didn't
said
answer my question.
that's not an answer, that's a word salad. I mean, there were 3 or 4 different words used there that I don't think a law professor would accept in an answer to a question like that.